Before we start the program, I would like to share some housekeeping information. First, this is not a CLE accredited program. Second, you may submit questions at any time during the program using the Q&A function at the bottom of the screen. Finally, this program is being recorded. Welcome to Red Flag Laws, Protections, and Pitfalls, sponsored by the ABA Criminal Justice Section. And now we will hear from Mr. Hoffman. Mr. Hoffman?
Thank you. Welcome, everyone. My name is Hillel Hoffman, and I am the chair of the Legislative and Policy Committee of the ABA Criminal Justice Section, and I am the co-chair of this webinar. And for the record, I am a retired Brooklyn Deputy District Attorney and a longstanding member of the Legislative Committee of the New York State District Attorneys Association. Our topic today is extreme risk protection orders, known colloquially as red flag laws. These laws are currently in effect in 19 states and the District of Columbia, and they all have a common purpose of removing weapons from people who are a danger to themselves or a danger to other people, hopefully to prevent suicides, acts of domestic violence, or mass shootings at public schools or public places. In spite of these common purposes, there's really no one size that fits all. Many states allow a petition for an extreme risk protection order to be brought by a law enforcement officer or a family member who is threatened by gun violence, but 4 states require a petition to be brought only by a law enforcement officer or a state's attorney, and a small number of states allow petitions to be brought by a wider variety of people, such as teachers, employers, co-workers, medical professionals, and others who have been in contact with somebody who is potentially dangerous. 9 states require a court to advise the subject of the proceeding, the respondent, that he or she should promptly consult with an attorney and appear with an attorney at the first hearing on the petition asking for an order. But only 2 states, Colorado and Rhode Island, provide a statutory right to counsel to indigent respondents. There are many, many other examples of how these laws differ from state to state. Each one has its own unique characteristics. But I would strongly urge anyone who's going to represent either a petitioner or a respondent in one of these proceedings to study the state law, the law of the state that you're in, very carefully, because there are many, many provisions in these laws, buried in these laws, which are very important, having to do with the penalties for noncompliance, penalties for filing false allegations, and also the way these laws interact with other gun laws involving gun licensing and disabilities based on abusive use of firearms. We have a very good panel today, and they're going to cover a very broad range of issues. They'll talk about the protections that are offered by red flag laws, but also the pitfalls that we encounter in enforcing them. Our first 2 speakers will be Kelly Roscom and David Keck. Kelly Roscom is in DC and has been for the past 7 years the Senior Director of Law and Policy of the Coalition to Stop Gun Violence, and she is counsel to the Educational Fund to Stop Gun Violence. And in addition to being an expert on domestic violence, she specializes in drafting congressional testimony and in drafting and analyzing legislation. David W. Keck practices law in Oshkosh, Wisconsin. He specializes in criminal defense and family law. He's the project director of the National Resource Center on Domestic Violence and Firearms through the Battered Women's Justice Project in Minneapolis, Minnesota. And throughout the course of his career, he has shown a very strong commitment to working on behalf of survivors of domestic violence, and particularly the impact of firearms on survivors and their families. Kelly Roscom and David Keck have prepared a PowerPoint in which they will describe the correlation between the presence of firearms and the incidence of domestic violence. And they will review the federal law and some of the state laws that apply to risk protection orders. and they will describe some of the differences between extreme risk protection orders and domestic violence protection orders. Martin Sibeli is a criminal defense attorney who practices law in San Francisco, and he is the president-elect of the National Association of Criminal Defense Attorneys. Mr. Sibeli trains defenders on jury selection and on deselecting based on implicit bias and racism, and he will address due process issues and racial disparities in red flag proceedings. Sarah Connell is an assistant attorney general in the Domestic Violence and Special Victims section of the Office of the Attorney General of the District of Columbia. She conducts detention hearings, plea negotiations, and she has handled many, many trials and proceedings on behalf of domestic violence victims. And she will, excuse me, she will discuss her role in handling a proceeding to obtain an extreme risk protection order. Anthony Holloway is the chief of police for the city of St. Petersburg, Florida. He is the co-chair of the Law Enforcement Committee of the ABA Criminal Justice Section. He is also chair of the Professional Standards Committee of the Florida Police Chiefs Association. And in response to Florida's red flag law, the Marjory Stoneman Douglas High School Public Safety Act, I think I got that right, Chief Holloway is going to present statistics, policies, and procedures of the St. Petersburg Police Department relating to risk protection orders, and he will also be presenting a PowerPoint. Guy Archidiacono, my colleague from the New York State District Attorneys Association, is a deputy bureau chief in the Appeals and Training Bureau of the Suffolk County, New York District Attorney's Office, and he is the attorney in charge of the Psychiatric Litigation Unit, which is responsible for hearings to determine defendants' competence to stand trial. He also does evaluation of possible not responsible defenses based by reason of mental disease or defect. He does post-commitment retention proceedings, and he provides information for civil commitment proceedings. He is a co-chair of the Mental Health Committee of the ABA Criminal Justice Section, and he will discuss balancing the removal of weapons from persons suffering from mental illness against the risk of stigmatizing mental illness. Finally, I am extremely grateful to my co-chair, Professor Andrew King Reese, who is the chair of the ABA Commission on Domestic Violence, Domestic and Sexual Violence, and who teaches law at the Blewett School of Law at the University of Montana in Missoula, Montana. Professor King Reese made his staff available to us to put this webinar together, and I'm especially grateful to the counsel to the Domestic Violence Commission, Vivian Welko. And finally, I would like to give a very big thank you to Patrice Payne, the senior staff attorney for the ABA Criminal Justice Section, who has done a terrific job in coordinating this event. Each of our panelists will speak for 10 minutes, followed by a 30-minute question and answer period. And I hope those of you who are watching the webinar will post your questions in the question and answer format. So we will begin our program now with Kelly Roscom and David Keck.
Good afternoon. I'm very happy to be here with you all today. And if you'll bear with me, I will share my screen and hopefully you will see our PowerPoint presentation. All right, so Dave, you just let me know when you need me to advance the slides.
I will, thank you, Kelly. Okay, initially what I was asked to do and what we're looking for here today is really sort of the history behind the extreme risk protection orders, how they kind of started out kind of in following from domestic violence protection orders, but also to talk about sort of the intersection between domestic violence and those protection orders versus extremist protection orders. There's some overlap, but also there are some important distinctions we wanted to make. The statistics here showing that half the, or probably more than half the women murdered in this country are murdered by a former intimate partner or sometimes a current intimate partner. And over half of these are are killed by firearms. The numbers of women who have been assaulted with firearms is staggeringly high. In addition to that, many more women and I guess also male victims of domestic violence report having been coercively controlled by firearms that are never actually fired or never actually brandished in the traditional way. But domestic violence as a basis for a protection order really is founded essentially on research and statistics that have shown these numbers and have shown the connection, and also a connection between, which we'll get to in a few minutes, between removal of firearms from domestic abusers and reduction in intimate partner homicide. So next slide. Federal law provides for 9 different categories of individuals who are not allowed to possess or purchase firearms or ammunition. 18 U.S.C. 922 sub G sub 8 is for domestic violence protection orders. Sub 9 is misdemeanor crimes of domestic violence. What's required under sub 8 for a protection order to trigger the federal prohibition is notice and an opportunity to be heard. It's just sort of a standard due process requirement that is really for all protection orders. There has to be an intimate partner relationship between the two individuals. Has to also restrain the respondent from harassing, stalking, or threatening, or the court makes a finding of a credible threat. It's important to note that this prohibition applies to firearms purchase or possession. It does not, federal law does not authorize or even speak to firearm relinquishment or dispossession or surrender, they sometimes call it. So that, where it's practiced, that is done by state law or sometimes some communities that are relying on federal law. So federal law puts the prohibition in place, but does not authorize or speak to the actual relinquishment of firearms. Next slide. Again, not mandated. Some states authorize it. I think there are about 17 states currently that either mandate firearm surrender to be ordered by the court, or else authorize the court to do so. It's important that to point out here, really, and we'll get into this in a few minutes, but the distinction between domestic violence protection orders and extreme risk protection orders is that the purpose and the focus of the protection order is on preventing harm to the complaining witness, to the victim. The firearm prohibition, and in those cases where firearm surrender or dispossession is ordered, those are consequences of the protection order. So there's a big distinction between those and extreme risk protection orders, which really have the removal of the firearms as the focus. Next slide. Statistics have shown, and Professor Zioli, if you ever get a chance to see Professor Zioli's presentation on this topic, is I think probably the most comprehensive that's been done in this field. Over a period of about 35 years, they've studied a number of over 20 states. There's a reduction in the incident of intimate partner firearm homicide, but at the same time, there's a reduction in the incidence of intimate partner firearm homicide, which suggests that there's probably a causal link between the access to firearms and the incident of intimate partner homicide. There's no causal link that's actually been proven, but there's a suggestion here that the so-called substitution effect, as Professor Zioli refers to, has been shown not to be validated by research. That the substitution effect is when someone says, well, if you take the gun away from the abuser is going to use another means of committing homicide. strangulation or a knife or something like that. That hasn't been validated by the research. In fact, the research shows that just the opposite, that the overall homicide rate is reduced by removing firearms. Next slide. That's you, Kelly.
Thanks, Dave. So we also wanted to give a brief history of the extreme risk protection orders. So the first law of this kind was passed in 1999 in Connecticut following a shooting at the Connecticut Lottery. And this was actually at the time and still today referred to as a risk warrant. So somewhat different from the extreme risk protection orders and red flag laws as we know them today, this established a process that allowed state's attorneys, assistant state attorneys, or two law enforcement officers to seek a warrant to search for and seize firearms from individuals if the judge finds probable cause that the person poses an imminent risk of personal injury to himself or herself or to other individuals by possessing one or more firearms, and that those firearms are within or upon a thing or person. And so if a judge issues this warrant, Connecticut law mandates that a hearing be held within 14 days to determine whether those firearms should be removed for up to 1 year or returned to the owner. So similar but somewhat different to the ERPOs as we understand them today. And this law was one of the laws at which the Consortium for Risk-Based Firearm Policy based its initial recommendation for what at the time they were calling gun violence restraining orders, which is the name of the law as it passed in California. And the idea behind this was to expand the pool of petitioners to include not just law enforcement officials, but also family or household members, and to move it from a warrant-based procedure to a civil order in which a respondent is ordered to surrender firearms to law enforcement in a specified time frame. So that is the law that passed in California, though it has since been expanded to include additional petitioners, and the final order has been expanded from up to 1 year to between 1 and 5 years. So lots of changes going on in the extreme risk protection order landscape. Washington was another one of the early states that had passed extreme risk protection orders as we understand them today. They did so by ballot initiative in 2016. As I mentioned, this law allows law enforcement or family or household members to petition for a civil order that prohibits a person who poses a significant danger of causing personal injury to self or others from having in their custody or control, purchasing, possessing, or receiving a firearm. And this also required the individual to surrender any firearms or ammunition in their possession to law enforcement, and established two different types of orders, an ex parte order and a final order. It also outlined a number of different factors that judges should consider when determining whether or not to issue one of these ERPOs. So relevant factors include recent acts or threats of violence by the respondent against self or others, whether or not that violence or threat of violence involved a firearm, a pattern of acts or threats of violence by that respondent towards themselves or others, a violation by the respondent of a protection order or no contact order, or a conviction of the respondent for a crime that constitutes domestic violence. And I've highlighted several terms as it relates specifically to the connection between these extreme risk protection orders and the domestic violence protection orders and domestic violence generally, to show that there is this sort of overlap in the sense that incidents that could give rise to the ability for an individual to seek a domestic violence protective order could also give rise to the facts that would allow another person authorized under the extreme risk protection order statute to seek an extreme risk protection order. And so, as I said, they can and they are being used in cases of domestic or intimate partner violence. So for example, in California, a 40-year-old man sent a text message to his fiance threatening to shoot her. He visited the fiance's ex-boyfriend, threatened to kill him while holding a knife behind his back. So police utilized California's extreme risk law to temporarily remove both a handgun and an AR-15 from this man. And so one of the things that Dave and I are going to be talking about quite a bit more during the course of this presentation is the importance of being very thoughtful in determining whether or not to utilize these extreme risk protection orders in cases where another individual could possibly seek a domestic violence protective order, or perhaps in some circumstances has considered but decided it is not in their best interest, not going to further their safety to seek a domestic violence protective order or an extreme risk protection order. Dave, did you want to go over these?
The distinctions?
Yes.
Okay, I can't quite see all of the PowerPoint, but I guess petitioners generally are the victims, or in the case of someone who is not able to petition on their own because of their age or because of their condition, are usually victims who do that. It looks like in extreme risk protection orders, it's generally law enforcement or household members, somebody who has that direct contact. I guess the distinction again is the one that Kelly was just referring to here is, and the important distinction is those petitioners who come to the attention of law enforcement because of a complaint or concern about their personal safety, and then law enforcement makes a determination to seek a extreme risk protection order to remove firearms when the victim may not actually be asking for that and may actually feel that they're in more danger by doing so. That's the one concern we have. The other is the concern that because these two types of protection orders have different bases and different standards, that courts may tend to conflate the two standards. In other words, in a protection order for domestic violence, not order of surrender of firearms because they don't feel that the ERPO standard has been met. So that's one of the other main concerns we have regarding the two types of protection order.
Yes, and as Dave mentioned, the types of relief that are available between the extreme risk protection orders and domestic violence protection orders are incredibly different. Extreme risk protection orders are focused solely and exclusively on access to firearms. So the types of relief for an extreme risk protection order are to prohibit purchase and possession of firearms, also sometimes ammunition, and to require the removal of firearms, sometimes ammunition, and often firearms licenses in the possession of a respondent. On the other hand, domestic violence protective orders offer a much wider array of protection, which may include, the cessation of abuse, orders to stay away from the protected party, their home, their workplace, their school, to prohibit contact with that protected party, whether that's in person or electronically, to order support like child support, the exclusive use of a home or a car. The relief available varies by state and can sometimes include a requirement to remove firearms and ammunition and firearms licenses. But as Dave was mentioning, domestic violence protective orders provide a lot more because their sole focus is not simply to remove firearms.
In fact, domestic violence protection orders with a firearm surrender order may not have any testimony or any evidence of use of firearms at all. It isn't necessarily the focus. Sometimes it is, of course, but it isn't necessarily something that's even going to come up in the hearing. And it sometimes is ordered whether the petitioner is requesting it or not. It's just ordered because of the status of the respondent at the time the order is entered may switch to one that prohibits them from having a gun, and the court may be mandated to order surrender, which is a much different scenario than you have with extreme risk protection orders, which focus on likelihood to use a firearm.
And as we mentioned before, ERPOs are, I think, an important and valuable tool, and certainly, I think, valuable for persons working in domestic violence prevention. But again, they may not always be the best tool available in that toolbox. And determining what the best option should be should always involve input from a survivor who's often in the best circumstances to understand what is going to be best for their safety. And ERPOs should certainly not replace the need for robust firearm removal policies related to domestic violence protective orders and domestic violence misdemeanor convictions. So as Dave was mentioning, there's also the difference in standards of proof. So we used California here as an example of this difference. And as Dave was mentioning, perhaps we'll also elaborate on, we don't want either advocates, survivors, or courts to be confused about these different and varying standards.
Nor do we want courts to deny that relief because of some, confusion about what the standards are, whether you have to meet both standards for both types or whether you just rely on what the statute says.
Thank you, Dave. So that concludes our formal presentation, but there will be a healthy question and answer session at the end of the presentations, and we'd both be happy to answer any questions you might have.
Thank you.
Kelly and Dave, during the question and answer period, I would like to ask you, Dave, I think you've done some writings on military families, or I would ask both of you whether there are special problems or other things that you deal with military families where guns are likely to be more present. And also, I believe, Dave, you did a PowerPoint or a speech on the effect of COVID-19 on families. So I've written down these questions, and I think we should cover them in the question and answer period. And I think at this moment, we need to move on to Martin Sabelli, who will tell us about the pitfalls in enforcing red flag laws. So thank you both very much. That was really quite excellent.
Thank you. Good morning, everyone, or good afternoon, depending on where you are, under 10 feet of snow or out here in sunny California. Happy holidays. Thank you for the invitation. It's an honor to be with you folks. I am probably the least well-versed of this group in terms of this specific issue, but I come at it from a criminal defense point of view. I've been in the trenches about 30 years, and so my perspective on this is to try to understand the application of these laws, the construction and applications of these laws from the point of view of the constellation of rights and interests that individuals have in the criminal legal process. So let me just start out by two sort of 50,000-foot view observations. The first is to the extent that we want to move away from what has been called classic policing to more holistic approaches, we need reasonable legal constructs to do that work. And what Kelly and David are talking about are reasonable legal constructs in order to do that work, to allow for more holistic understandings and policing and control of these issues to reduce the amount of violence. That segues into my second observation, which is that these issues can be looked at from really three different lenses and should be looked at from three different lenses. The first is this notion of how many lives are being lost right now, given the proliferation of firearms in the United States and their use in these kinds of situations that Kelly and David have talked about. So there's the public health paradigm. There's also the criminal legal defense paradigm, which involves due process, effective assistance of counsel, mostly representation, and some other issues. So there is that paradigm as well. Are we guaranteeing people's rights as well? And the third paradigm is the racial justice paradigm. In this era where we're all waking up a little bit, to the profound biases in the criminal legal process, both implicit and systemic, it's very important in the same way that in other sectors of the world we do environmental impact studies, we need to do a racial impact or racist impact study in this area as well. So my view is, yes, we need more holistic policing, but we've got to look at these laws from the three paradigms: the public health paradigm, the due process paradigm, as well as the racial justice paradigm. In terms of the due process paradigm, we have to understand that even though these are civil laws, they have criminal legal implications, and people are being charged for violations of these laws. So it's not simply staying in the civil realm. And I think most of you folks know that and understand that. We also have concerns that are related to the fact that they can be proved up with uncorroborated hearsay. And quite often there is, as Hillel pointed out, no representation or simply a suggestion that you should go talk to a lawyer. And so while there are liberty implications, there isn't necessarily representation here. And from the equal protection or the racial justice point of view, there are some serious concerns. There's a terrific article that I'll cite later, a couple terrific articles that I'll cite later that for those who are particularly interested. And I saw a question on there from a former colleague from the San Francisco Public Defender's Office about this issue, Stephen Zollman. So I'll be sure to refer that article. But at the 50,000 foot level, we have a history, a country in which about half of white respondents in studies report having gun access, whereas something like a little bit less than a third of people of color report having gun access. And yet the numbers in terms of the enforcement of these issues seems to be disproportionately higher for people of color. So that raises concerns that ought to be looked at, and I'll try to flag some of those issues. So for the next few minutes that I have left, I'm just going to try to flag some issues that I think would be ripe and interesting for discussion when we open the floor. So first of all, from the due process point of view, we've got the issue of right to counsel. It's a major right, and most of the laws don't provide that. Hillel already gave a sort of a survey of that, but only 2 states, Colorado and Rhode Island, provide that statutory right. Other states say, go talk to a lawyer, go consult with a lawyer, and that's an issue. So in very concrete examples, you're subject to one of these laws, a gun is taken, firearm is taken from you, you're told to sign a receipt. Signing that receipt could have huge criminal legal implications. And if you're doing that without having talked to a lawyer, maybe it's truthful, maybe it's not truthful because you're just signing the receipt because you're not thinking clearly and it really isn't your gun. And then you're stuck with that admission without having consulted with a lawyer or without having understood the criminal legal implications. That's serious from my point of view and can result in prison. Even if it doesn't result in prison, it can result in criminal legal implications that end up with people losing apartments, jobs, and other sorts of situations. So it's a serious concern. The right to counsel is very important. Searches. Quite often there are authorized searches that don't require any kind of Fourth Amendment finding. That's a concern. Where laws don't have adequate or specific guidance for law enforcement officers about how to conduct work, there is the possibility of arbitrary or discriminatory application. And of course we know, and this is not a moral judgment on anybody, there's a lot of systemic racism in the legal process and implicit biases, putting aside explicit biases. There are people with that explicit racial bias, but even people who don't have that have these implicit biases. All of us do. And if you've taken the implicit bias tests that are available, which are highly verified and reproducible in terms of science, we all know that all of us have implicit biases. It's not a moral judgment. You can have implicit biases about your own ethnic background, your own gender, everything. And so if those exist in all our communities, in our police officers, our judges, our public defenders, our criminal defense attorneys, our prosecutors, of course, they're going to play out in this system. There's no way for that not to happen. And so And I'll come back to that a little bit later, but right now I'm looking at the lens of simply of having sufficient clarity for law enforcement officers to reduce the implicit bias in the application of these laws. And of course, because many of these processes are ex parte, there's always a danger of unverified, unchecked, unconfronted information being used to result in something that ends up on somebody's record permanently or ends up in criminal charges permanently. And so to come in for a landing on racial justice, which is the last area I want to cover, you know, so far I would say that focused on this tool, the perspective has been, how do we save lives? This is a public health problem. People are being killed, people are being threatened, people are being hurt. And I totally empathize with that, I get that, and I support that 100%. But we need to start looking at it as well from the due process point of view and the racial justice point of view as well. We can't forget that in many of these cases, under many of these laws, these orders are sought upon application, most of them by law enforcement officers and approved by judges. And if we understand, this is my perspective, I'll just put it on the table, that criminal legal processes, like all legal processes, are pervaded by implicit bias. And this has been studied, and this is not a talk on implicit bias, but there are lots of implicit bias studies on this. If the criminal legal process, including law enforcement, is permeated by implicit bias and systemic racism, then how can it be that the application of these laws wouldn't also be affected by that? Of course it is. There's no way to be part of this system and not have that leak over. And so we really have to build in some protections so that we do not contribute to the continued unequal application of legal processes in a way that's discriminatory and damaging to people of color in this country. And when you couple that with the understanding of the discriminatory application of historically of gun laws with respect to people of color, that's a big issue. So what we're talking about here obviously are not the intended consequences of the law, but the unintended racial impact or racist impact of the law. So I promised to refer to a couple of studies. One is by, there's a summary by Jeffrey Swanson called The Color of Risk Protection Orders, Gun Violence, Gun Laws, and Racial Justice that summarizes some of the literature in the area. It's a very useful piece. And there's a epidemiological study. See, I could get that word out this morning. It's early and caffeine levels are sufficiently high that I got that word out right. On the implementation of extreme risk protection orders in King County in Washington. And that is by a scholar named Frattaroli, F-R-A-T-T-A-R-O-L-I, and that's a 2020 study. And it shows that people of color, Black people in particular, were overrepresented in gun removal orders by a factor of nearly 2 to 1 compared to their share of the population. So that causes concerns, but to come in for a landing, I understand and I support the notion that we need to protect lives, that there's a public health emergency here that needs to be addressed. My concern is always, and maybe the best example of this is Tip O'Neill, Ronald Reagan, and mandatory minimum crack cocaine. It all got done in about 3.5 minutes. And we've lived with the terrible mass incarceration consequences of all that. You know, when Len Bias died and everybody wanted to pass these laws, and we've been recovering from that mass incarceration effect for 30 years. I want to just sort of plant a flag in the ground right now and say, yes, we need to do something about this, but we need to be very aware of the due process, right to counsel, and equal protection dimensions so that we don't have this the same sort of regretful conversation 20 years from now about the impact of these laws. So thank you all for letting me participate. Thank you all for your great work, which is saving lives. But let's not forget that if this is not done the right way, some people are going to be hurt, and they're going to tend to be poor people and people of color. So thank you for the opportunity to participate.
Martin, thank you very much. And you've raised some really very good points. And I hope that in the question and answer period, that you will raise them again and give our other speakers a chance to respond to you. At this moment, though, we do have to move on, and we got to hear from law enforcement. Sarah Connell, and followed by Anthony Holloway. So Sarah, please take it away.
Okay. Well, I will start by responding to Martin, and I'll say, as somebody who practices in this field of law and actually does these cases in court, I can say the things that Martin has said ring so true, and especially I think the right to counsel in these cases for indigent people would make a really, really big positive difference in a lot of the implementation of this law. So I'll just say that. So I'm with the DC Office of the Attorney General, and one of the things that I do is I handle the majority of the extreme risk protection order cases in the District of Columbia. And as of now, as of today, I've been involved in 6 different cases and had several contested trials. I actually have one next week, and we're doing them remotely at this point, which has been interesting. I'm not going to tell you the details of the DC process because everybody is from different states and it varies from place to place, and that could just be boring, non-useful information. But I'm going to use my experiences being in court and seeing the, I don't want to say dirty side of all of this, to give all of you pointers, and especially to give all of you who haven't actually seen how this really plays out in the courtroom. In practice, to see just what my experiences are specifically with the District of Columbia. So I'll start with starting a case. Obviously, these cases start by having somebody draft a petition. Depending on who can actually be the moving party in this case, depending on your state, it's going to be a different person. In DC, for example, it can be law enforcement. It can be a medical professional. It can be somebody who has certain defined intra-family relationships who can actually petition this court. And people can petition for an extreme risk protection order. They can do it completely pro se. Or you can have an attorney do it for you, whether somebody hires a private attorney. Very often we, as the Office of the Attorney General, get involved in it pretty early on. I will say you don't have to be an attorney to petition one of these, and like most things, when an attorney gets involved, things tend to get a lot more complicated and slow down way too much. So especially in emergent situations, I usually think somebody going ahead and getting this process started without an attorney is just as effective. And obviously, when you're filing for a temporary extreme risk protection order or starting the process, one things you want to look at is what kind of information do you need? And you would want to look at the statute. When we are looking at Washington State and looking at what the judge there needs to consider when deciding whether to grant an order, those factors, mental health, domestic violence, history of using guns or threatening to use guns, those are all things that you want to make sure that you put into a petition. I would say not less is more, but more is more. So especially if you're a pro se person, you want to advise somebody to put in as much as they know. You might be a pro se person filing for one of these and you might know nothing about guns. I ask people to just describe it as best as you possibly can. You don't have to know all the details of what the gun looks like, etc. Something else you want to find out for your state, which is really important, is that in DC, it's not necessary that you have seen this person with the gun or that you know that person has a gun right at that time. We have a protection order we got where somebody was just threatening to get a gun to do something. So that's not necessary in the District of Columbia, and it may or may not be in the jurisdictions where you are. So that's starting a case. Now, after I'm not going to so much talk about the temporary ex parte. Generally, the rules of evidence for those are a little bit looser, but I'm really going to be talking about how to build the case to get what in DC is a year-long extreme risk protection order. So what witnesses would I bring? I've used all kinds of witnesses. And one thing I'd really advise people who are doing these cases is to think as creatively as possible, because some cases you're going to have lots of medical people, no law enforcement, some just civilian, no medical. So really think about it. I've definitely used law enforcement witnesses, especially when the law enforcement have been the moving party and we're representing, the US Attorney General is representing the individual from law enforcement. You might have somebody who responded at one point, and when they responded to this person, they had significant safety concerns. One of my cases was a law enforcement officer who went to serve something at the home of this person. And when she knocked on the door and said law enforcement, she heard the round of ammunition being put into the gun and right at the door. And that was something that we used. That testimony was something that we used in the case. But sometimes you also have law enforcement who really know this respondent extremely well. They have had a long-term relationship with them. Sometimes when people have severe mental illness, they might have, for better or for worse, they might have had a number of interactions with law enforcement. And so you might get an officer who has a 10, 20, 30-year relationship with this person who can come talk about that person's struggles and the concerns that they see. That also can be helpful. Medical witnesses. I've also used a number of medical witnesses, and this can be anybody from obviously a custodian of records, which unfortunately we need still to get in business records in DC, although that's not the case with federal rules of evidence, a custodian of records to get medical records in, or you might call somebody who has been a treating psychiatrist or nurse practitioner in a facility, or somebody who's had an ongoing relationship with this respondent. However, I would advise everybody to really think long and hard about this, and I'll explain why. If somebody is a respondent who has been experiencing a number of mental health issues over the years, and say they have a 10 or even 1 year relationship with somebody who provides mental health assistance, to subpoena that person, to make that person come in and essentially say everything about this respondent and their mental health is would feel like a huge breach of trust, and also would have a serious chilling effect on that person getting mental health assistance in the future. So I think that that's something, depending on who you're actually representing and depending on a lot of different factors, you really need to think about in each individual case. Can you get these medical records and just get them in with the custodian without somebody having to come in and answer all these questions? Do you even need these medical records in the first place? So that's something else. And then also to talk about other witnesses you might have would be co-workers, civilian witnesses, people with personal relationships. Also, this can get tricky. I try not to force people to come in, because sometimes people feel as though they're either breaching some kind of really important trusting relationship, or they feel like they're putting themselves at risk by coming in. So I think that that's something also, you can get civilian witnesses. If it's somebody just interacted and doesn't really have a relationship with this person, that tends to be a little bit easier. But I want to say something about using domestic violence survivors in this situation. This is something that's already been brought up, but my history, I've been working in the field of domestic violence prevention for 30 years now. And so in my cases, of these 6 cases, a number of them have had either a domestic violence, there's been a domestic violence relationship at some point where the respondent was abusing a domestic violence survivor who may or may not have actually been the petitioner in this particular case. And I've really left it up to that individual person whether they want to be part of this case, because it can be at great personal cost to that individual. And as somebody already said, I think Kelly said, you have to rely on that person's perception of the situation as far as what kind of level of danger they're going to be in. So what I do is usually, if there is somebody who's had a history of violence, I contact that person, I find out about it, and I explain to them what the process will look like. Do they want to be involved? If they don't, then I don't. But I'll look at other ways of potentially getting that in that evidence, whether they're 911 calls, any kind of excited utterance, are there criminal convictions of protection orders, etc. in the end. Now, just lastly, talking about preparing and introducing evidence, obviously using these witnesses. Again, you have to look at all the factors and use these as a guide for your evidence. What are the factors that you need to show, and obviously what your burden of proof. Most important is, of course, do the rules of evidence apply? I know when I've talked to other practitioners around the country, they've told me that even in the permanent or the 1-year orders for these protection orders, the rules of evidence, the standard rules of evidence do not apply. In that case, there's a whole lot you can bring in. If they do apply, then obviously you're in a different boat in terms of the hearsay, et cetera. In DC, when you're getting the permanent or 1-year orders, the rules of evidence do apply. And so we have, that's how we've sort of developed our case. What I would say is the best evidence generally these cases that you could get are usually statements by the respondent, him or herself. So this could be body cam from a responding officer. It could be 911 calls made by the respondent, by a spouse, by a witness, and maybe you'd be able to get that in without the person who's, you know, the proponent of that statement actually being there. Could be statements, writings, text messages, voicemails made by the respondent. And then lastly, medical records, of course, can be very, very important. But again, there is that tricky side to medical records, because, you know, we're all told when you go to the doctor, nobody ever is going to get this information. And then suddenly somebody files this extreme risk protection order against you, and it's being presented literally in a public forum, which is what it is in DC Superior Court. Anybody can walk into that courtroom and hear all of this information. So I think that has serious, serious implications for people, which leads me to my very last point. And this is something that I wouldn't really have realized until I started doing these trials and doing these cases. These are cases when you're in the courtroom where many private issues and some of people's absolute worst, lowest points in their lives are going to be on display for the public to see. And there can be an enormous amount, unfortunately, of shame for these people in this. And this is really, really difficult for that individual person. So if you're handling these cases, I just would urge you to keep that in mind and try your best. And this is something I'm not saying I do it perfectly, but I really try to minimize the shame, minimize any kind of humiliation. There are certain things I have to get into evidence that I have to present to the judge, but I'm always mindful of how this is impacting this person who is already suffering a great deal. And also in cross-examination, you know, you might want to get out certain facts, but trying to trap somebody and make them feel worse than they already are, I think that in the end, this will really just create more problems. So you have to be mindful going forward what this individual respondent is, what their life is going to be like. Sure, that maybe they'll have a year when they can't get a gun, but how is this going to impact them? And then the safety levels beyond that. And that's why I believe right to counsel in these kinds of cases could be absolutely critical to sort of really minimize that and increasing the chances that these cases could settle without a trial, which I think also could really minimize that shame that somebody would feel. Thank you.
Thank you very much. Wow, that was extremely informative, really excellent. And I learned a lot, I can say that. We're now going to move on to Chief Anthony Holloway, who I think will give us the police law enforcement perspective on enforcing these laws. So Chief Holloway, please take it away.
First of all, thank you very much for having me here today. And I think Kelly, David, Mart, and Sarah's done a great job for laying that foundation about law enforcement. And I think most here in Florida, Sarah does it the right way. There should be only one lawyer handling these cases. So I work for St. Pete Police Department. We are the 5th largest city in Florida, and we're in the 6th largest populated city in the state of Florida. Our information came about through, get my screen up here. Risk protection order came about doing the Stoneman Douglas High School. Everybody's aware of that, where a child went to the school and he shot several people there. Hopefully my screen's up, you can see it. Where several people were shot, and basically everybody had all the signs that something was going on, but no one knew exactly what to do and how to handle that. So so the risk protection order came about. And I think what Martin said earlier was the biggest thing with looking at law enforcement, to make sure that law enforcement does not misuse these powers that were going to be given to us. And a lot of these officers are unfamiliar with the Second Amendment, but they're being told that they can take weapons out of the house. So the biggest thing was, how do you go about doing it and to make sure you do it the correct way? Kelly and David did a great job explaining the foundation of it. And then Martin talked really about what a lot about law enforcement thought about, how we're going to make sure that we do this the correct way, that we're not violating people's right, that we're making sure that we're looking at our implied bias, because everyone does have that, and how these cases will work. So what we did was we looked at all the cases that we had coming for us, and our budget and our fiscal years from October 1 to September 30. And we looked at all the cases, and we figured out the best way to do is to make sure you have a check and balance system put in place. So the officers have the basic foundation. He or she will go to the house, take the report, make sure they have all the right information that Sarah was talking about, the documentation, so that they can prove that if they do not take the weapons out of home, someone can and possibly will get hurt. Once that report is completed, then it's reviewed by a sergeant to make sure that everything is in there that needs to be in there. And then after the sergeant reviews it, then it goes to a lieutenant, and he or she will do the same thing. So there's two sets of eyes before the case is even forwarded to the court. Once the report is completed, here in our system then it goes to two different parties. One goes to our legal division that we have here at the police department to make sure, are there any training issues that we need to address? Are there any biases in there? So they look at the information I'm here to show you a second. And then the fourth part of the leg is shipped to an attorney that's going to handle the case in court. What we've seen throughout Florida is some agencies allow the officers to go to court and become to present the evidence. That wasn't working because the officer's not a lawyer, and he or she didn't know exactly what was going on, and they saw a lot of cases being thrown out or just not enough information. So just being able to give that information to a lawyer, because again, like I agree with Sarah, their personal lives are being put out there for everyone to see, and to make sure all the documentation is done. So what we've also looked at is then seeing, is there any races or any biases that are being done? Those the cases that I showed you there, as you can see, 81% of the cases that have been made since 2007, 81% of those are males that have been involved in that. And then we said we want to do a deeper dive. What exactly are you talking about as far as race? Then we break it down to race. And again, this is done every month to see exactly what cases are being shipped off to the state attorney's office for presentation, and to see if there's any training that's need to be given to officers. Then we look at the type of cases that are being made. First thing we looked at is a baker out here in Florida. That's a mental health issue. And as you said earlier, we came about this law because we were seeing there was a public health emergency, or again, there was a mental health issue that needed to be addressed. And we needed to get these weapons off the streets so there would be a potential for someone not to get hurt in the future. So again, we just want to make sure we covered all those. So again, in the Baker Act, you can see where we started tracking those. And then the next group we looked into was domestic violence. And when you look at the ones for 2019 to 2020, that's a little bit comes into COVID. We were trying to figure out exactly where those numbers were. And we saw those numbers go up within that period of time. So again, we were asking officers, what calls are you responding to? What's the probable cause for the arrest? And again, do we need to take those weapons out of the home? And again, having those positions in place where everybody's reviewing, where there's a sergeant, lieutenant, and then you have your legal counsel to look at to see what other training that is needed to make sure that, again, you're taking someone's weapon away from them. So again, are you violating their rights, or what else can be done before you take that weapon out of our homes? Since we've started this in 2017, I can tell you here in Pinellas County, we've had no issues with taking the weapons. 90% of the cases are holding up in court. The people are surrendering the weapons at the time the officers are at the homes, to making sure that we do not have to go back and get a search warrant to remove the other weapons out of the homes. So I'll end right there for any questions for me.
Tony, I was just wondering, I know that in other states, I think in Colorado and in Virginia, the sheriffs or police officers in some counties announced that they were going to set up Second Amendment sanctuaries. And I wonder whether any of that has happened in the state of Florida, or any of your colleagues may or may not have been involved in that. But it does seem to me that in some places there is very strong police resistance to removing these weapons based on Second Amendment issues.
I can tell you here in the state of Florida, I have not seen that. I chair a few committees, and that has not been brought up. Because all the checks and balances that are put in place, that the men and women, before they take the weapons out of home, they're gonna have to really have documentation why they're taking the weapons from the person at that time.
Have you experienced, or your deputies experienced, any armed resistance by respondents who are very angry and upset and don't want to give up their weapons, or threatening the officer who tries to remove the weapon?
And as I said, since 2017, since we've had this risk protection order in place, we have not had those issues. The officers are able to talk to the person at that time, and everyone has surrendered their weapons. And then again, the people that did want their weapons back, they have gone through the court proceedings to either get their weapons back, or the court has decided to keep the weapons for a year. In some cases, we've had some extended now to 2 years.
And do you have experience with young juveniles? I was going to call them offenders, but these are civil proceedings. But are there juveniles involved in these cases who are brandishing weapons?
We've had some cases where juveniles have brandished weapons, but we have not gone through an RPO. The biggest cases, again, we're handling are the domestic violence and the Baker Act. And again, those are adults that we have been dealing with.
What is the Baker Act?
I'm sorry. So here in Florida, Baker Act is someone, their mental capacity is just to the point where they just need to be put in some place. They're a danger to themselves and a danger to the community, and you have to prove that.
Well, the Florida statute has been a model for quite a number of other states. Close to half the states passed their laws after the Stoneman incident. And there's some similarities in the language, but I think the Florida statute certainly was the motivating force. So please, yes, if you'd like to.
I'll just say, and everyone, just like you said earlier, everyone was afraid when the RPO was being issued that law enforcement was going to go kicking everyone's doors and take all their weapons. And that has not happened. I think we've proven to everyone that, again, it is a health issue, a mental issue, and we're just trying to make sure we take those weapons off the street so either a family member or someone doesn't get hurt. So I think people are realizing that what they thought was going to happen has not happened. I haven't seen that, nationwide.
Well, thank you very much. That's really good to know. And I think at this point, we will now segue into the topic of mental illness, which I think everybody has made some reference to. So I'd like to turn over the discussion to my colleague, Guy Archidiacono.
Thank you, Hilly. Good afternoon, everyone. One of the concerns with ERPO is that it may further stigmatize mental illness. And that's a pretty tricky problem because it doesn't start with ERPO and it doesn't end with ERPO. Mental illness often has stigma. And as Sarah noted, shame and being stigmatized may be made worse when you go through one of these petitions, and some of that information is publicly raised and publicly acknowledged. And so I'm not sure I'm going to be able to offer too many answers to that, but I hope I can give you at least some other factors to consider. First of all, in New York, for example, mental illness is not one of the enumerated factors. It's not specifically enumerated. There are other reasons why these petitions might be brought. For example, you might have someone who's just very angry. Doesn't make them mentally ill. You may have someone in despair, someone who is immature. You might have a lonely, isolated person. You might have someone with, for example, psychopathy, which is not a mental illness. And so these are just a few of the reasons why people may be creating a risk either to themselves or to others. And mental illness isn't involved in any one of those. And yet sort of the elephant in the room is mental illness, because so often that is what people are focusing on. You know, resolution in a criminal case often focuses on punishment and retribution and confinement and rehabilitation. Purpose of ERPO is protection. And the irony is that very often the person being protected is the respondent. For example, Ron Honberg of National Alliance for the Mentally Ill was testifying in Congress, and he pointed out some statistics on ERPO and suicide. That suicide is the 10th leading cause of death in the United States. In 2016, nearly 45,000 deaths were by suicide. For young people ages 10 through 24, it's the second leading cause of death. 20 veterans per day die by suicide. Veterans account for 14% of all suicide deaths. Nearly half of US suicide deaths are by firearms. And 60% of gun deaths are from suicide. 90% of suicide attempts with a gun result in death. And the CDC estimates that a half of all suicide deaths are by people who were diagnosed with mental illness. So again, you have that problem. You have people who, you know, may have a mental illness. It may make them prone to suicide, and we have to strike that balance. We can't ignore the fact that they may be in danger, or that because of their condition, they may be endangering someone else. But how do we, how do we reduce the stigma of mental illness? And that's, I think, a very difficult question. And I note also Professor Bonney from the University of Virginia pointed out that suicide is a compulsive act. And so sometimes proactively removing a weapon from someone who may have a tendency towards suicide is protecting them, because that gun is not going to be available for them when they act impulsively. None of which, of course, undoes what can be the stigma of mental illness. What are some of the other factors that laws recognize when you're proceeding with one of these petitions? Ron Honberg pointed out in his testimony a number of evidence-based factors that increase the risk of violence. A history of violence, which actually, whether it's in this context or the context of let's say a not responsible plea in a criminal case, that is the best predictor for future violence, past violence. A history of physical or sexual abuse, abuse of alcohol or drugs, domestic violence, past convictions for violent misdemeanors. And so those are some of the factors that a court might consider. In New York, we have a number of factors that we can consider. Threats or acts of violence, a recent violation of an order of protection, or a history of an ERPO violation, pending charge or conviction for weapons possession, reckless use, display, or brandishing of the firearm, recent substance abuse, or recent acquisition of a weapon. And in those definitions, you notice repeated use of the word recent. And I think that goes for mental illness as well. How recent was the mental illness? How relevant is it to the charges, or rather to the petition and to the factors that are raised in that petition? What kind of mental illness was it? There are many mental illnesses that don't implicate dangerousness. And so what specifically is that mental illness, and is it even relevant to the discussion in a particular case? Looking forward, ultimately, I guess the real point is that ERPOs were have been adapted so that you can balance the safety of the public and the safety of the individual against that individual's right to privacy, his right to bear arms, his rights not to be stigmatized in public, in a civil proceeding that may be based on a petition by someone who has no background in, say, mental illness, for example. Might be brought by a family member or a law enforcement agent who really knows nothing about mental illness. So, what do we do as a short answer? I think there are a number of things you can do. That if a respondent has a history of mental illness, if that is part of the petition, that it's considered only to the extent that it's relevant and in context. Is this something that in the past that has caused violence? Will raising this mental illness, if it's only marginally relevant, is it going to have a chilling effect, as Sarah noted, on future petitions, or on, say, a respondent being willing to quietly acquiesce to an order? And so, it's a hard problem, but the problem is that very often mental illness is inextricably interwoven with these petitions. And so I don't think there's any easy answer. One other thing I've noted is that there are some use of words that offend people. I understand that red flag laws, for example, some mental health advocates feel is offensive. And so certainly we can change language like that so that we're not refocusing the purpose of that ERPO, which is to protect lives. So with that, Hilly.
Guy, in your general practice in the DA's office, how many of your cases, with just ordinary criminal cases, how many of them involved technically defenses based on mental disease or defect, or how many of them, if they haven't even raised that defense, there's still a very strong component of mental illness on behalf of the defendant?
Well, one of the things I do, Hilly, is I handle the not responsible pleas we take in the office. Over the years, I think the defense has been asserted, I would say something like 150 times. We have, over the years, I think we accepted about 120 pleas of not responsible. Only 2 of those were by trial. And the reason for that is that everybody was willing to sit down and go through the medical record, the mental health records of the defendant with an open mind about whether that mental illness was the root cause of what they did, whether their behavior was the result of that mental illness, and therefore this person should be treated rather than punished. Also, when you go through that analysis, there is a risk assessment. There's a number of risk assessment tools. One of the ones they use in the criminal case is the HCR 20, which looks at historical risk factors, and it looks at clinical risk factors and risk management factors, which is really not so different from what we would do in an ERPO petition. Again, you need a risk assessment tool that tries to put in perspective, did the mental illness have anything to do with the crime, and to what extent, and does that change the way the case ought to be handled?
Guy, how many of those cases would have involved weapons, guns?
Off the top of my head, probably most of them, if not virtually all of them, really.
So even in the direct enforcement of the criminal law, there are still the very same issues of removing guns, or the gun being an issue in the case involving a criminal defendant, and the implications of that, whether there's a commitment or are there seizures in those cases?
I'm sorry, are there
seizures of the guns?
Of course, yes, absolutely. Absolutely. And also when you have a criminal case, it is also similar to ERPO in that much of the mental history may go back decades. And again, you have to go through it and see, is what somebody did when they were 22 relevant to what, where they are now at the age of, 53? So again, there may be an element of mental illness, but it really may have absolutely nothing to do with why they did or didn't do what they're charged with.
Well, Guy, thank you very much. I think we have to move into the question and answer period. And I hope some of you will jump right in there because a lot of questions have been raised. I was thinking particularly of the issues that Martin raised about implicit bias and due process. And I was wondering whether the other panelists who have dealt with these ERPO proceedings, whether you have perceived that there might have been racial bias in the enforcement of them, or whether you were concerned about the lack of due process procedures and right to counsel. So I invite everyone to please jump in and let's hear what your opinions are. Sarah, have you had experienced that in the district? A disproportionate number of cases involving African American or Latino American respondents?
Well, we have, just to answer another one of the questions, we've only, I think, had 8 cases filed total in the District of Columbia. So these cases are not brought very often. I think there are a number of reasons for that. One of the reasons is that we have very strict gun laws anyways. So most people are not supposed to have guns anyways. Still, you might bring a case in those situations. I think that's part of it. I think also there are many people of color specifically in the District of Columbia where filing for an extreme risk protection order is essentially, if say I'm doing it against my son, right, my adult son, it's essentially asking the police and the system to sort of come into my home, potentially search the home, come serve, and sort of inviting a justice system, which I might not, some people might not perceive as going to be fair to me in the first place. So I think that there's a lot of concern, particularly with people of color in DC, of involving the criminal justice system through a civil case, even though it is civil, the remedies are criminal. And even in DC, if you give up your gun and you're not supposed to have it, say you have it illegally, you give it up when the police serve you, there is immunity for that. But I think people still distrust whether that's real immunity or it's sort of immunity, and whether that's going to lead to some further law enforcement action. So I think that that's part of it. In terms of the cases, I think the respondents of our cases have been fairly, I think there's been the breakdown of the races of the respondents in our cases has pretty much probably reflected the racial breakdown of people in DC, except it has all been men. So that's that. And then obviously due process issues, it's a huge concern of mine. And I believe that hopefully that's something that we're going to be able to look at, because when the respondents in these cases and they're standing up there and they're making statements and they might be representing themselves and they're making all sorts of statements which potentially could be incriminating. And I think that, you know, that as a government employee, that makes me really uncomfortable. And so that is a huge concern, and it's something hopefully we're going to address.
Well, thank you. I think if we go to the Q&A on the bottom of our screen, I'm looking at a question that came from Stephen Zolman, and it says, with the topic being addressed, how would you address systemic racism that continues in our criminal and family law system? That's quite a question. So does anybody want to jump in there and answer that?
Well, I've pointed Stephen to a couple of resources that he can take a look at. I think that the question is a very, very broad question. It's a great question, obviously. It's a necessary question. It's one of the lenses that all of you have been using and that I urge that we use as well. But I think that there is no simple answer to it, because implicit bias and systemic racism permeates every aspect of our legal processes. We have to be on guard and examine everything from that point of view. And I use the analogy of a environmental impact sort of approach, well, let's look at a racist impact or a racial impact as well. So for example, where there is, as in California, some association between the existence of criminal history with the either the enforcement or application of these laws, we would need to take a good look in the same way that we do with respect to risk assessment tools, whether or not the underlying criminal predicates have some sort of racial aspect, like the law that doesn't exist anymore now, but did exist in Louisiana until somebody was killed enforcing it, not being able to wear baggy pants that are below your butt, right? Well, that is a law that has a racial impact, and if you have to actively filter for that in the application of any law. So Stephen's question is a great question, but it does not allow for a simple answer. Every aspect has to be looked at from that lens. And so Stephen, I thank you for raising it the way you did. I think the answer is that we have to be systematic in addressing and looking at every aspect and not taking for granted, as we historically have, that there are some sort of objective measurements like, you got a criminal conviction, well, that must mean something about you. That's not necessarily true. It might mean that you're smoking marijuana in a park. You don't have a house to smoke marijuana in without somebody telling you not to do it. And so that has a racial impact and a socioeconomic impact. So thank you for asking the question, but I don't think there's a simple answer. And take a look at Swanson's paper, the one I cited. It raises many very interesting, direct, and practical dimensions, Stephen, that might be useful.
A question from Debbie Lindgren. Can you show the first slide of the presentation when it is over? I would like to see the credentials again. So I think the first slide, Kelly and Dave, can you show the first slide again or announce to our viewer what your credentials are?
I would be happy to pull up our first page of our PowerPoint, and David, sounds like you want to just talk about our credentials as well.
Yeah, I think we're both JDs, both attorneys. I am the director of the National Resource Center on Domestic Violence and Firearms. I've been an attorney for 27 years.
And I think hopefully everyone can see this page of the slide. And if you don't mind, I'd like to say just one thing about the previous question, which is not necessarily a way to address the systemic racism in our criminal justice system, but certainly something that would be helpful as we think about this, and something our organization, as we assist in providing review of proposed legislation, is asking for the collection and analysis of data related to the ERPOs, including allowing access to de-identified information by researchers. Like Martin mentioned, Jeff Swanson, whom we work with a lot, has been working on getting access to ERPO-related data, something we're trying to integrate into the existing ERPO statutes, but also as we pass new ERPOs to ensure that there is both access to that information and that somebody is looking at it to see what exactly it means.
I jump on that point very briefly because this is really for Sarah. I think she would be the right person to address this. But when we've, in other contexts, have talked about what Kelly has just raised, the collection of data, that can be problematic in some instances. I've had U.S. attorneys or prosecutors involved in discussions about reform say, we really can't track that, or we shouldn't track that. That we don't want to track that in a way that has an impact on our charging decisions or our other decisions. And so I think Sarah could probably speak to that because it's a really important point, the data collection point, but it has complications.
All right, I'm going to read our next question from Tim Carey. Can ERPOs be enforced across state lines, i.e. an ERPO issued against the respondent in state A, so the respondent moves to state B and purchases a firearm? So would anyone like to tackle that one?
Mhm.
It would seem to me that I don't know whether these orders are given full faith and credit or not, but I do think that the issuance of an order in one state certainly would have implications in another state. And if that order was judicially entered and a court could take judicial notice of it, I think it might have an effect in a new application where the court would then see that amongst the other factors for granting the extreme risk protection order, one had previously been granted in another state, assuming that it is still in effect, because many of them expire after 1 year. But I think it has what we might call a collateral consequence. But I don't know, unless a particular state law provides that it will enforce an out-of-state order, I don't think they can get translated across borders. Would anyone else like to offer an opinion on that?
So I know that many states are working on this, and very few of the ERPO statutes include full faith and credit provisions. And of course, unlike the domestic violence protection orders, there's no federal statute related to full faith and credit of ERPOs. But that's also something that may hopefully be addressed in some recent legislation, which also establishes a grant program for training and implementation of ERPOs in states that have passed them. It was introduced last year and is, I think, planned to be introduced again this year. So it's certainly something that people are thinking about. And for those of us who are working on drafting, I know that we've been in touch with the National Center on Protection Orders and Full Faith and Credit to try to, gain the value of their expertise, having worked on this in the domestic violence space for many decades.
Kelly, have you spoken to the Uniform Law Commissioners? Is there any movement on foot to have a uniform ERPO law? Because it's only in 19 states. We've still got plenty of other states to go.
So that is an interesting and timely question. I actually did participate in a study committee of the ULC a couple years ago. It was proposed that they establish not a uniform, but a model law for ERPOs. Unfortunately, the ULC decided not to move forward with a model for a number of different reasons. I think one being the fact that many states already had an ERPO statute, but also it is somewhat more controversial than the other issues that the ULC has provided guidance on in the past. So I do not believe you'll be seeing any model legislation on ERPO from the ULC anytime soon.
Well, that's interesting because I think they circulated to us at the ABA a proposal on a uniform setting of bail statute, which is certainly also, I think, a very controversial issue these days. But in any event, let's see if we can answer a few more questions here. The next question is from my colleague, Sherry Levin-Wallach from the State Bar Association. And she says, other paradigm is the mental health in New York. In New York, the judge is making that determination without professional evaluation. So has this been a problem in some of the cases that you've handled, all of you, where there is a real issue of mental health, but there's no mental health professional who's called either as a petitioner or a witness? And do you kind of have to wing it if you don't have a mental health professional?
I can start by answering that. In my cases, I've tried to, I believe, two, and the one I have going to trial next week, two, and the latest one that I did, we did have mental health professionals and people we qualified as experts also, because I actually wasn't sure about that's sort of their there's a lawyer understanding of certain mental health diagnoses. And then, so I have erred on the side of being careful and trying to get experts in there. That's what I'm doing next week, and that's what I have done previously. But I've also had judges draw conclusions just based on sort of lay definitions of what they would consider indicia of somebody with mental health issues. But I will say this, our statute has a number of factors and mental health is one of them. And really the way our judges have ruled is that you don't have to show something in every single factor, like violence, mental health, domestic violence, et cetera, et cetera. It's just sort of a sum total. So we don't have to have the mental health component. We don't have to focus it specifically on the mental health component. So if we don't have a professional, I don't think it's the end of the case, but I think it's good for the record and it's helpful to the extent that you can have somebody qualified as an expert to explain. I think that is useful.
Well, I'd like to ask Kelly and Dave, when you bring a proceeding on behalf of a domestic violence victim, do you on occasion reach out to a mental health professional to give some evaluation of the defendant's respondent's behavior?
In a domestic violence case, I've never done that. I routinely do domestic violence protection orders here in our community. I've done them for a number of years, but as far as establishing a mental illness, that's something I've never had an occasion to do. It's more a question of whether or not this person presents a risk to the client.
Yes, and Kelly, have you had occasion to reach out to a mental health professional as a witness in one of your cases?
No, and I want to clarify, I don't do any direct survivor services providing. I don't represent clients. I work primarily in the legislative and policy space.
Yeah.
And I don't want to go too far afield, but I wanted to touch on a theme that Guy was mentioning. And this is the idea that when the Consortium for Risk-Based Firearm Policy first proposed the idea of an expanded version of these ERPOs, which now exist in many places, it was framed as not being based on mental illness. The idea was we wanted to move away from this stigma associated with mental illness, but also the idea that we can address the potential for violence without having to provide a mental health diagnosis. The idea behind the ERPOs was to be very behaviorally based, whether that is due to a mental illness or whether that's due to completely different circumstances. Like I was saying, it could be somebody who's angry, somebody who's experiencing difficulty at work, the loss of a relationship, other things that can cause people to experience crisis and contemplate either self-harm or harm to others. And this is the way we've been attempting to frame the use of this tool since we first got involved in crafting the legislation in California, was that this is not a mental health tool per se. This is a tool to help prevent access to firearms by persons in crisis, whatever that reason might be, which doesn't necessarily answer the question being asked, but I think we tend to think of ERPOs perhaps a little too narrowly. And it's often tied to mental illness in a way that I think can be detrimental to the use of a tool. We see so many cases where respondents will voluntarily hand over firearms. They won't fight the issuance of the ERPO, and in fact are very grateful at their final order hearing that they had this intervention, that this was for their benefit. And so I'd like to see a shift in the way we talk about some of these cases, because it's not meant to be punishment. It's not meant to be, consequences for wrongdoing. It's meant to be protective either for that person or for somebody else, regardless of the reason that they are in crisis.
Well, another question that, I'm sorry, if someone else would like to.
Sorry, just really quickly,
Sure.
I was going to say, on top of what Kelly just mentioned, I think there's a popular perception among the public, at least, that someone who's inclined to commit domestic violence must have some kind of mental illness that's driving that. And I don't think that that's true, I think that puts too much of a burden on the petitioner, on the victim, to prove that there's some basis for that, when that's really not what she's asking for. They're asking for protection from that behavior, not an explanation for why the behavior is that way.
Well, Sherry has another question also, I think, related to this topic. She says, another issue with ERPO is the medical records or testimony used in an ERPO hearing can then be used in a criminal proceeding or be part of the discovery for a criminal proceeding. Issue for discussion: should medical records testimony used in ERPO be sealed and prohibited from being used against the respondent in a subsequent or simultaneous criminal or other court proceeding? So, Sarah, I would start with you. In the district, if some sort of medical or psychiatric testimony has been admitted, let's say as one of the factors in asking for the order, do you have is there a prohibition in the DC statute which would prevent that from being used in evidence in a criminal proceeding? Or can it be subpoenaed by a prosecutor in an let's say unrelated criminal trial?
Well, we put it this way: we haven't had that situation happen yet. I do know in the new law there was something specific about sealing the records, and I'm looking for it right now. Our law, it keeps changing every few weeks, not quite every few weeks. But I would say this: the records themselves. So if they are entered into evidence, I don't. So if somebody has the right, just because I enter records into evidence when I'm representing somebody civilly, who is the petitioner in a case, and I'm in possession of them, does not mean that the U.S. Attorney's Office, for example, when prosecuting something, can, because we have a weird prosecutorial structure in the district, that the U.S. Attorney's Office automatically has the ability to get those records from me. They would likely have to go through or supposed to go through the same sort of procedure that I went through to get them, which is a specific order from the judge and showing good cause of why you need it, etc. That said, given that these are public proceedings and people can get transcripts in and people can sit there in court, and now people can videotape because everything's on Zoom, I think that is something that could certainly be a concern. We haven't had enough cases to see if that was going to happen. In our civil protection order cases, domestic violence protection order cases, there are some specific protections for respondents in those cases regarding use of that in criminal cases. But I'm glad that that's been raised, because I think that's something has not come up, but absolutely needs to be looked at, because very often that's information which probably would not be allowed in a criminal trial, but could potentially start the search of some, forbidden fruit, or be the beginning of a search that ends in something where it implicates somebody, and perhaps investigators should have never had that information in the first place. So I think that's something we really need to consider, and I'm going to look for that sealing part of the statute.
Anthony, I'd like to ask you that if your office is involved in the enforcement of an ERPO, could you be subpoenaed by the district attorney to turn over your records in a criminal proceeding?
The answer to that is yes, because they get all the information on the case. I heard another question I'd like to answer to. Someone was asking about the return of weapons. What we're seeing is someone is going through a mental health issue. They're not getting their weapons back, and they're not petitioning to get their weapons back. But people that are involved in domestic violence, after that year, they're trying to get the weapons returned to them.
But in order to get the weapons returned, under Florida law, don't they have to go through a proceeding, sort of the reverse of the ERPO, where they have to prove to the court that they are no longer a threat to anybody, to themselves or anyone else?
That is correct. So they have to go through the procedure like they did a year ago.
Yeah. Well, Martin, it looked like you wanted to jump in there.
I did. picking up on Sarah's analysis, which I agree with, I'd like to frame it this way. There are concerns related to privacy, particularly medical privacy, in the context of seeking these orders. There are the same concerns, along with other sets of concerns in criminal processes. The fact that some evidence may be admissible in the order context doesn't make it admissible in the criminal context. I don't think it changes the balance. Anybody who wants to use those records still has to show relevance and some other avenue for bringing it in, overcoming whatever it is, hearsay objections, privacy objections. It is not made public record necessarily because it's in the order context, and there should in fact be protections from making it entirely part of the public record. And I think that's why we have judicial officers to balance and to decide whether or not individual mental health related information should be made public. It could be accepted as part of this process, but not made public. You can have redacted documents, you can have under seal documents, and the fact that it's used in that context doesn't mean that it's out in the public world and can be grabbed by anybody. There's a little bit of a problem, and this is why I jumped in, but Chief Holloway knows a lot more than I do. When you turn it around and you're trying to get your firearm back, I don't have a firearm, but I know people try to get them back. And there you might affirmatively use the evidence, and there the calculus might be looked at differently by some people if you're affirmatively putting it out there. But again, I think judicial officers have a series of concerns and a series of tools for redacting or sealing private personal information, and they ought to do it. And I want to thank Sarah in her initial comments way back in the beginning when she acknowledged the devastating effect of having these things talked publicly. And it can destroy people in so many different ways, from self-esteem to jobs to everything else like that. So the responsible release of medical information has to be a focus here. And I'm very grateful that this has been brought up by so many different people today, but first by Sarah.
We have a question here, and I'm not sure that, I don't know quite how you can answer it, but it's from Bonnie Carlson. Could you say the name of that resource again, the color of something about race and POs, I guess protective orders? I'm not sure whom that question is directed to. Does it resonate with anyone?
Yeah, it resonates with me.
Yeah, okay, go, shoot.
And it resonates with David and Kelly because they probably know it better than I do because they work with Jeff Swanson, and it's called the color of risk protection orders, gun violence, gun laws, and racial justice by Jeffrey Swanson. It's in the injury epidemiology. See, I blew it that time, from 2020, and it cites other studies as well. So it's an excellent resource, and perhaps Kelly and David have something to add because I know they work with him.
Okay, thank you. Let's go back to the videotape. And I see another question there's some from Sherry, but I'd like to give someone else a chance. An anonymous attendee asks Sarah Connell, why do you think DC's ERPO law is so underutilized?
I think I folded this into the answer of another question, but lots of gun laws, and I think mistrust of the criminal justice system for very obvious reasons. And this is a way to sort of invite the criminal justice system into your home. So yeah, I think I already sort of addressed that. I'd be interested if anybody else has any opinions on that too.
Sarah, I totally agree with you. Before we try to take a weapon from someone, we really want to go through a big, like say, a checklist, because you just don't want to take guns away from on every call, because sometimes it's not necessary. Someone is thinking about committing suicide. You may not want to just take the guns out just because they're talking about killing themselves. So again, because that's what people will start looking at. Are you going on every call and removing weapons from a home?
Chief, there were two questions, I think, for you. So I'm going to give you one and then give you the other. This one is from Sherry Wallach. Question for Officer Holloway. How many of your cases have had a criminal justice case as a result of the issuing and search pursuant to the ERPO, or a criminal case that has sparked the application for the ERPO? So I guess it's looking at it both ways. ERPO leading to a criminal case or criminal case leading to an ERPO.
Well, domestic violence, that's going to be, of course, a criminal case. And in the reverse part of it, not too many of those cases. So again, if we're going to a Baker Act, that's not a criminal case. Someone's asking for help. In a domestic violence, if we can make a case on a domestic violence where a weapon is being used, then that's where that would be used.
Well, the other question, this is from Kate Donahue. Do you struggle with whether to do a Baker Act mental health commitment versus an ERPO? People who are involuntarily committed to a mental health institute are already barred from purchasing firearms under the federal Brady Handgun Violence Prevention Act. We struggle sometimes in making determinations on whether to prosecute an ERPO, expending resources and risking officer safety, as well as getting the appropriate access to determine whether the individual is already on the NICS no-buy list due to a previous mental health commitment. So I guess the question in the beginning is, do you struggle with whether to do a Baker Act mental health commitment versus an ERPO proceeding?
No, I think those are two different things. You're there first for the Baker Act, just someone going through a mental crisis. And then the second part is, by taking the weapons out of the home, are you protecting that person and then protecting someone in the future that they, again, it's the threats that the person is talking about. If the person is only talking about killing his or herself and they need help, I guess I'll use our policy. There's no reason to take those weapons out of that home. Now, if that person is saying that they're going to use that weapon to hurt other people, then yeah, there's a reason, there's a cost to try to remove those weapons from that home.
All right, here's another question from a detective named Brad Baker. Hi, I am a detective with the Denver Police Department who handles our ERPO referrals and investigations. We are coming up to the end of our first year of our ERPO law. Several cases are coming up for consideration or renewal. How often and what challenges have others faced with the renewal of ERPOs?
And I think that came back, I think one of the panelists answered that question. If it's a health issue, then they're gonna have to really prove to the courts that that issue is going away, i.e. Baker Act. We are seeing, again, like I said earlier, the domestic violence cases where the subject or the suspect, they want their weapons returned to them. So I would say about 80% of domestic violence cases, people want their weapons back. Someone that's going through a mental crisis, they're kind of happy that the weapons are out of the home, and we don't see those coming as an issue. They surrender their weapons to law enforcement.
Sarah, do you have many instances where they want their guns back? Or are they willing to just surrender them?
Oh, no, people, well, I assume a lot of people want their guns back. But I will say for us, for the renewal or extension of extreme risk protection orders for us after the year, the onus is really on the petitioner, whoever that is. So we haven't had that many that have expired, but generally we will contact the petitioner. And what we really look at is, have there been any significant incidents? And this is really, it's so fact specific, you know, really depending on the situation, but have there been some recent incidents that have occurred since the issuance that would really cause new concern? And if there have not been, then very often they just expire on their own. And at that point, the person could just go back to get their gun at that point. So it's not something that it's the burden of the people who took the gun in the first place. And I don't know if people have gone back to get their guns, to be honest, but I would assume so.
There's a question here from Tommy Fitzgerald. Does anyone have any statistics or knowledge of the numbers of respondents who ever get their guns back? And I think I would offer part of an answer is that most of the state statutes do require the Office of Court Administration, or in New York State, I think it's the Division of Criminal Justice Services, to keep track of the fate of all of these petitions. So my guess would be that in individual states, where they have set up the record keeping function. They probably do have records at this point, depending on how long the law has been in effect, of the number of motions that were made for the return of weapons and what the dispositions were on those motions. But I would think that it would have to be done on a state-by-state basis at this moment, unless we find that somebody has written a national study analyzing all of the returns of weapons, how many motions have been made, how often are they granted, et cetera, et cetera. And the flip side of that is that petitioners can petition to extend the period. Many of the states provide that you can extend for another year. So I think it would be an equally relevant statistics to balance that out against the number of cases where courts have extended the extreme risk protection orders. So if anyone else would like to jump in, please do. All right, we have a question here from Debbie Lindgren. In Oregon, the ERPO law was passed in 2017, enacted in 2018. It is nearly 3 years old, but it is not often used throughout the state. Visibility seems to be hindering its use when it could be very effective. Any suggestions to let the public as well as law enforcement know about the law for the future? Any ideas?
Well, so one idea is certainly one that I've already mentioned, which is the introduction of this federal legislation providing grant funding for training related to ERPOs as well as implementation. In addition, I think other groups like ours who do educational components on ERPOs in states that we work in, we are a very small organization. There are only about 15 of us. So we do what we can, but also engaging with groups on the ground, you know, and ERPO attracts, I think, a variety of different individuals interested in the fair and equitable implementation of this public safety tool. So I'm thinking, you know, mental health organizations like NAMI, other gun violence prevention organizations, domestic violence prevention organizations, to engage with individuals, providing materials at places that people might be interested in picking it up, like doctors' offices and other places like that for education.
Well, I noticed in some of the materials that I went through in preparing that there were some references to the Violence Against Women Act and the involvement of the Justice Department and possibly giving grants. Is that program still viable? Are they still giving grants to various programs or projects that deal with violence against women? And could red flag laws be included in a grant from the Justice Department to educate, you know, people, the states like Oregon and other places where they have the law but nobody knows about it?
Quickly, the Violence Against Women Act hasn't been renewed. It was passed the House almost 2 years ago. Senate has not taken it up. So I think that's kind of the short answer. But I wanted to comment quickly on Kelly's point and on the question that was just asked. Firearm relinquishment, you know, surrender orders in domestic violence cases has actually been practiced for a number of years. But the reality is, even though about 16 or 17 states have laws that require or authorize it, it's really practiced systematically in very few places. And I'm almost going to go so far as to say it's probably occurring across the country right now more frequently in ERPOs than it is in domestic violence protection orders. So the question that was asked, I think, is a very good question. And I think it's something that everyone needs to look into, is why aren't these laws being applied more frequently?
Yes.
And if I could jump in there, I would say, we talked about earlier, there's a lot of sheriffs and a lot of police chiefs that are afraid to touch it. Just because of where they are. If you're a sheriff in a certain area, you're not going to touch this. And if you're a chief, I work for the mayor, so I have to make sure that the mayor that I work for is also on board with that. So it really comes down to what community that you're in and what community wants to support that part of it. So I think that's where you'll see is enforced different way in different areas.
Well, Tony, also, aren't some of the sheriffs elected
Correct. So they're going to go exactly what the constituents want to do. So
They may face a Second Amendment backlash. I think that may have been the problem in Colorado and probably in Virginia.
you're absolutely correct. Election was up this year, and a lot of sheriffs will say, "I'm not touching this," even though they've been. I think Kelly said, they've been trained. There's training that's out there, but no, I'm not going to touch this one. This is a hot potato, and I'm going to leave this one alone.
Yeah, I was trying to jump in and I was going to tee it up for you, Chief Holloway, because that, I wanted to hear from you on that. To me, it feels a lot, and I hate to bring this up right at the end here, but it feels a lot like enforcement of the mask orders in some way, where there are some local political pressures. There are also some personal beliefs on the part of some law enforcement officers. It makes it a very complicated issue, which has local dimensions, also has racial impact as well, urban versus rural impact, as the chief has pointed out. It's a very complicated question. To come in for a landing here, my name is really Martin, not Martin, because I grew up in Argentina, and Argentina is so divided politically, and we're starting to see that We see that in the United States in a profound way, and of course that has a profound impact on how laws are enforced. So this is a sticky wicket.
And I think I say here in Florida, we have 67 different counties, and I guarantee you it's done 67 different ways.
68, probably.
Well, I'd like to, I think we're running out of time at this point, but I'd like to end this with a thank you for Kelly. So maybe you have it on the screen, Kelly, but it says, this is from Eileen Zeller. Thank you, Kelly. I was typing a comment about that point. ERPOs need to be based on dangerous behaviors, not diagnosis. People with mental illness are significantly more likely to be victims than perpetrators of violence. So if you'd like to comment on, I thought that's a nice accolade.
Yeah, just thank you. We've been working really hard, and I know Guy mentioned Ron Homburg that we've been working with, trying to frame these laws. And again, I want to mention that there are a number of individuals within the mental health community who do find the term red flag to be incredibly stigmatizing and off-putting. And I know we've gotten some pushback on that, and it's an incredibly popular name. Apparently, it's easy. I think it rolls off the tongue. It sounds a little bit easier and more accessible maybe than ERPO, and perhaps the name is something we're going to have to work on a little bit. But I do think there's something to be said for whether we understand it or not, listening to individuals who are most impacted by stigma of mental illness, who are telling us that this is not language that they appreciate hearing, and adapting to that, and being very mindful that if this is a population of individuals whom we want to reach out to, and we want to provide this sort of intervention, antagonizing people and pushing them away in this manner is not the way we're going to do it. So thank you.
Well, we've just received the 2-minute warning from our Commander-in-Chief, Patrice Payne, that she has to move on to another webinar at 4 o'clock. So at this point, I would like to thank every one of you. I think you've all been great. And this has turned out to be an extremely interesting and informative session. When in the early days, I was hoping we could get through an hour or an hour and a half, but we've done 2 hours today. And I have a feeling that probably we could keep going for a little longer, but the powers that be are telling me that it's time to pull the plug. So thank all of you very much, very much. Thank you for volunteering, and thank you for your excellent presentations. This was really a terrific webinar. So have a good evening, everyone.
Happy holidays.
Thank you. Thank you.
Holidays, everybody.
Thanks.
Thank you.